And hello, everyone, and welcome to Uncivil Law, where we continue to learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are continuing our coverage of 7M versus Catherine Joy Paulson, also known by her channel name of Without a Crystal Ball. This continues to be the best lawsuit that we've seen against Catherine Joy Paulson because, as we've discussed many times, all the other ones have been varying degrees of bullshit. There was the Toddy Westbrook one. There was the Steve McRae one, kind of, sort of, but not really, because he pocket served and then proceeded to not do anything for a year. So that case went bye-bye. There's the Todd Chrisley lawsuit, which continues to make absolutely no sense, at least in my humble opinion, and other things. She seems to attract a lot of garbage lawsuits against her, people who just want her to shut up. And you can't just sue people because you want them to shut up. You actually have to have a cause of action, and 7M does, at least on its surface, of course, because that's all we've analyzed so far. We've analyzed the complaint, and yeah, 7M is making a lot of claims of defamation, including some fairly extreme stuff that Catherine Joy Paulson has said about them, relating to trafficking in people, among other things. So, some fairly aggressive claims. And 7M has sued and made it past the motion to dismiss. And this past Friday, they filed for a protective order and for an injunction. They'd like to get Catherine Joy Paulson to stop talking about them. Now, it's one thing, of course, once you've won a lawsuit, right, to get them to stop repeating the lies that got you there in the first place. But asking for a restraining order for speech in advance of speech, well, that's prior restraint. And that runs into a whole nother scope of problems, right? If you want to punish someone for something they said after they said it, in a formalized process, of course, and you get a formalized court order relating to that speech, you can do that. But, of course, Catherine Joy Paulson hasn't been found liable for anything yet. We don't know legally that her claims are defamatory or her statements are defamatory. They look on their surface, they meet the prima facie standard. So we got that. But it's quite possible, of course, as case goes on, that, Catherine Joy Paulson will be able to make out her claims. Now, 7M does have a lot of statements against her. They went through quite a lot of detail in their claims. So, if I'm a betting man, I would think it's unlikely Catherine Joy Paulson is going to be able to make her burden. But of course, I'm not going to prejudge it before I see it. I'll just simply note there's a lot of it. A lot of it's very specific, and a lot of it is very aggressive. And so, Katie Joy Paulson, as always, says she has the receipts, and you can only say, well, you hope so, because there's a lot that you have to overcome. But that's for the future. For the moment, let's deal with the issue before us, which is this motion for a temporary injunction. There's also a 3-page motion that parallels this for a protective order, basically saying the same thing. This one actually has some verbiage. So we'll go ahead and read this as well. All right. So plaintiff respectfully requests this court grant the motion for a temporary injunction enjoining the defendant from posting any online content about plaintiff 7M or its associates until this court adjudicates on the merits of the lawsuit. So right away, at least for me, I'm thinking to myself, we have a problem, right? This is relating to speech that, at least to this point, has not been found legally to be defamatory. And also, it's relating to any online content. So that's a lot. I mean, it's a fairly broad request, perhaps too broad in a lot of ways, but that's what they're asking for, at least. In the alternative, if the court decides that a temporary injunction of all posting is inappropriate, at least this jurist would be disinclined to grant one that broad, except in the most compelling of circumstances. And, for all that there is, this is not that. Plaintiff respectfully requests this court requires defendants include with every post she makes about plaintiffs or their associates that in the picture and block of the text relating to plaintiff and its associates that she's currently engaged in litigation. Yeah, I don't know about that either. Yeah, that's asking for a lot. I'd be disinclined. Now, of course, for every word she says, it's going to lead to damages, right? It's going to increase her damages down the line if she continues to aggravate things. So I may not be able to bar her from saying it in the front end, but if I'm counsel for Katie Joy Paulson, I would encourage her to think carefully about future posts, because whether or not they're banned or not, if she continues to create problems, she continues to expose her liability. So that it would be a concern of mine that I would discuss if I were her attorney. The case involves the defendant's persistent and malicious harassment of plaintiffs through multiple social media platforms, including YouTube, TikTok, and Instagram. The defendants have used these platforms to publish countless amounts of false and defamatory statements about plaintiffs, including, as we mentioned, accusations of human trafficking, kidnapping, and waterboarding. Katie Joy Paulson has, in part, made these and other suggestions in her various posts. These are fairly aggressive accusations. It's not you're mistreating your talent, it's your waterboarding. So there's kind of a different kind there. Furthermore, the defense have demonstrated a dedication interfering with plaintiff 7M's contracts and prospective business relationships. Despite current litigation, defendants continue to post false and defamatory statements. Yeah, that is a problem. It is not necessarily a problem that I, as a court, necessarily can or should do anything about, because it runs into serious First Amendment concerns with the prior restraint. But if it ultimately pans out that these statements are not supportable, right, then it's going to lead to increased damages. I mean, of course, as always, truth is an absolute defense. So in the event that 7M is in fact engaging in any of these practices, well, that would be a valid thing. So, we can try that. But okay. A temporary injunction is appropriate because in its absence, the plaintiffs will suffer substantial and irreparable harm for which there's no adequate remedy at law. Yes, there is. I mean, that's what damages are for. Money, that's what money is for to some degree. On the other hand, the defendants will suffer little harm from being enjoined from posting about plaintiffs for the duration of the lawsuit, which is set for trial next year. It is set for trial in April right now. Furthermore, the factors under Dahlberg, which Minnesota uses to analyze whether injunctive relief is appropriate, weigh heavily in favor of granting a temporary injunction. I really, really hope they're going to do some specific First Amendment analysis in this, or I'm going to get salty. If they just go with the standard 4-part injunctive standard without discussing the obvious First Amendment concerns, which maybe they can get past. Maybe they can get past the obvious First Amendment concerns, but if they don't discuss it, I'm going to get angry at 7M. Right? I mean, you're asking for an injunction relating to speech. So, you might want to discuss the First Amendment concern. All right, let's see if they're going to do that or not. All right, so 7M is a California corporation. Robert Shin is the CEO and sole owner of 7M. The other plaintiffs, Miranda Derrick and James Derrick, are independent contractors of 7M. Defendant Katie Joy Paulson, also known as Catherine Mansky Paulson, is a resident of Minnesota where this is being sued. She is the owner of Without a Crystal Ball, LLC. Defendant Without a Crystal Ball is a Minnesota limited liability company. Catherine Joy Paulson, of course, runs multiple social media accounts. Katie Joy Paulson operates her social media accounts to publish sensational material to gaining viewership. Now, sensational, there's nothing wrong with sensational. Sensational by itself, of course, isn't illegal or improper. Sensational might be very proper. If you don't like Katie Joy Paulson, I'd just like to continue reminding everyone that not watching her continues to be an option. If you don't like what she says, there are so many other YouTube channels, including this one, mind you. Defendants use their following to monetize various social media accounts. That's kind of what we do over here in the social media world, yes. Defendants hold themselves out as established media personality and self-proclaimed internet troll. I believe she's used that terminology before, so, but either way, I don't care. right? Internet troll is not some sort of legal determination. So, sure, for whatever value it has, fine. Kathy Joy Paulson has hundreds of intentionally malicious and or recklessly publishing materials about various people and entities. Now, I will note here in their affidavit, which I will not read in full, but in their affidavit, the attorney included an affidavit that's like 30 pages long, and he includes statements that don't relate to 7M to prove his point, including, for example, statements about Todd Chrisley, where I think that Katie Joy Paulson's claims are much more legally tenable, as I've expressed many times. So to try to prove that she's a bad actor who says bad things about a lot of people, the attorney, at least in part, it says, here's some examples of things that seem to be protected speech based on my analysis. So that seems to be questionable in terms of a legal strategy, to be sure. I'm not sure why you can't just stick to your own lawsuit, to be quite honest, because the things that she said about 7M are worse and more aggressive than anything she's basically said about any of the lawsuits we've ever covered, at least. I mean, they're by far and away the most aggressive claims that she's made. So, well, I mean, I guess it's debatable with Todd Chrisley, but then again, with Todd Chrisley, the daughter says it's all true, which is where it's coming from. So, anyways, moving on, doesn't matter. You could just stick to your own thing. I think going to things outside that is a bit of a mistake. Katie Joy Paulson has expressed an intense obsession with plaintiffs. Okay. Katie Joy Paulson has demonstrated a commitment to interfering with 7M contracts. Debatable. And as the court themselves have noted in their denial of the dismissal, right? Everything kind of goes back to the defamation, which I think is true. So has she intentionally interfered with contracts? Well, as the court itself has said, everything kind of rises or falls with the defamation, which is often true in these kinds of cases. So I won't worry about the intentional infliction of the emotional distress right now because the court doesn't seem to. So I'm not sure why I should either. We'll just stick with the defamation right now. Okay, let's see. The defendants have made an immense amount of social media posts regarding the plans, which contain false and defamatory statements. Quite possibly, they are some of the most aggressive statements she has made about people to date. Defendants' posts have included accusations of heinous behavior. Yes. Defendants have stated 7M engages in human trafficking. The defendants have stated that 7M dancers exhibit signs of being trafficked. Those are pretty aggressive statements. You kind of hope that she has the receipts. It would be very helpful in particular if she has dancers or former dancers of 7M who can testify to their own experiences or things they personally witnessed that 7M did in their presence, like firsthand knowledge. That would be great. If she has that, then she's on her way. If she doesn't have that, she has problems. Defendant has stated that Robert Shin and 7M are predatory. That's the least of the problems. Defendants have stated 7M is a cult, and plaintiff Robert Shin abuses women. Abuses everybody, but sure. That's the idea. Defendants have stated that the plaintiff, Miranda Derrick, was kidnapped by plaintiff 7M. So one of the people suing is a person that Katie Joy Paulson said was kidnapped, and they're the person suing. So not so encouraging that Katie Joy Paulson has what she needs. But maybe, I mean, again, she might. It just, you kind of hope she has the specifics. Because apparently Katie Joy Paulson has stated that one of the plaintiffs themselves was kidnapped by one of the plaintiffs. But they're both on the same side of the lawsuit. So, that's a problem. Defendants have stated that plaintiff Robert Shin has watered board members of his church. That's a pretty specific claim. At least two dancers for 7M who defendants have commented about recently have responded to her social media posts saying it's false. This is not encouraging when it comes to Katie Joy being able to meet her burden. She has one of the plaintiffs is someone she said was trafficked or kidnapped in this case. She has two other dancers she said were abused who have said no. So she's got the people themselves saying it's not true. It makes the prospective ability for Katie Joy to be able to get to where she needs to be look more and more doubtful. You know, in response to that, especially of course, because it is not at all clear that any of the plaintiffs are public figures, which is not the case for Todd Chrisley, for example. Todd Chrisley has a reality show called Chrisley Knows Best. The show's about him. He's a little bit of public figure. So, actual malice. But the plaintiffs, 7M, Robert Shin, these other people, it's not clear, at least to me, that any of them are a public figure. And so it's not clear we have to show actual malice. We just have to show negligence. And, that's a lot easier. So I'm not at all convinced that she has to meet the higher burden for any of these people. Okay, in response to these dancers, defendant did not take down their posts and simply stated that they were her opinion. Yeah, that doesn't necessarily get you home. You can't just say my opinion and no, that's not how that works. Defendant Katie Joy, false and defamatory statements have damaged the plaintiff's reputation and standing. I mean, I would think to somebody. How much and to what community is, of course, for a jury to decide. So, how much has it hurt their reputation? To what amount? What can be quantified is for a different day. Of course, we do have nominal damages assumed by law because some of it's defamation per se. So you have nominal damages. So you got at least $1, but anything more than that, you got to be able to show. And I'm sure they'll be able to say it at some point. We'll see. Mama Six says, Kurt, do you think 7M has a good chance of winning this case? It's premature for me to say. I don't know. I don't know the answer to that question because I don't know what Katie Joy Paulson has, right? Because I, as always, try to assess these cases based on the official court filings, right? So I don't know what Katie Joy Paulson has. I know what 7M has to some degree because they've made more statements than her at this point, which is to be expected at this point of the lawsuit. They filed the complaint, of course. They've got one of their former dancers or one of their former people saying it's not true. They got statements from these other people saying it's not true. So I know a lot more of 7M's side of the story than I do Katie Joy Paulson's side of the story. And Katie Joy Paulson has not yet presented her side of the story in terms of receipts, in terms of what evidence she has. Now, she might start to present that, as we go forward in, for example, a motion for summary judgment. So I don't know. All I can really say is where we are at this point in the proceedings, right? All I said was, I think we're going to make it past the motion to dismiss, which we did. I thought they had more than enough for a prima facie case, which continues to be my opinion. I do not have any opinion at this time as to whether or not they will ultimately make it past a motion for summary judgment. I can say that 7M seems to have quite a bit of evidence in their favor. So it would seem that Katie Joy Paulson has problems and she has difficulties, which is about as much as I'm willing to say without really reviewing her evidence. So I don't know. I'll wait until she files and then I'll render an opinion. 7M by far and away has the best case going because, as they've themselves said, they've got some evidence on their side. What Katie Joy Paulson has on her side, she hasn't yet offered to the court. So I'm not in a position yet to state an opinion as to the balance of probabilities. That's about as much as I'm willing to say at this point. And yes, you can always settle a case. You can settle a case pretty much anytime. You can even technically settle a case after a judgment is awarded. A settlement is just an agreement between the parties. The parties can always agree to anything, basically, at any time. So yeah, basically, you can always settle a case. What 7M's motivation to settle is, but they can if they're both willing to settle, sure. There's nothing stopping you from settling at any time. You can settle after the judgment comes down. If you guys reach an agreement amongst yourselves, the court's not going to stop you. All right, so let's discuss a little bit more about what's going on in this request. Plaintiffs have served defendant with a summary of complaint, includes counts of defamation, defamation per se, tortious interference, commercial defamation, intentional infliction of emotional distress, negligence per se, deceptive trade practices, and intentional interference with prospective advantage. And as the court has noted, basically all roads lead to defamation, which again is very, very typical. All right. Defendants have made numerous statements about the lawsuit, including they will continue to report on the lawsuit and plaintiffs. Okay. After a brief pause, defendants have recently restated this harassment of plaintiffs. Recent posts have even included plaintiffs Robert Shin's daughter and son-in-law. Katie Joy is escalating. Maybe not the wisest course of action. I can't speak to what her attorney is advising her. It seems questionable at best to me. Despite ongoing litigation, defendants have stated that she is back to reporting on the 7M story and would not stop. It's come to the attention of plaintiffs' counsel defendants have recently been offered a Netflix deal and are actively being encouraged to post about 7M to promote the documentary. Okay. Well, this is novel information to me. If Katie Joy Paulson gets a Netflix deal for anything, you bet your sweet ass we will cover it. During the recent wave of harassment, defendants posted a screenshot where she admitted to interfering with plaintiff 7M contract with the Los Angeles Clippers. That's definitely one way of parsing that clip, to be sure. Yes, that she interfered. That's one way of parsing that piece of evidence, to be sure. The court should grant plaintiff's motion for temporary injunction. In the absence of the injunctive relief, plaintiff will suffer irreparable harm. Furthermore, the factors weigh in favor of the plaintiff's motion. Okay, sell me. Sell me on you want a preliminary injunction relating to speech. Temporary injunctions are governed by Minnesota rules. The rule states that a temporary injunction may be granted if by affidavit, deposition, testimony, or oral testimony, in a case it appears sufficient grounds exist. In order for a temporary injunction to be granted, the proponent must show other legal remedies are inadequate, and the injunction is necessary to avoid irreparable harm. That's pretty standard, right? Irreparable harm, you have to show that there's no adequate remedy. You have to show that it's in the public interest. You have to show balance of equities. It's the basic standard that we all know and love. Temporary injunctions are meant to preserve the status quo pending adjudication on merits. Because the applicant is asking this court to preserve status quo until trial, the applicant must have a valid underlying cause of action to proceed, which you do. That's fine. For a court to grant a temporary injunction, the first step is to determine where the requisite threat is present. The threat and injury must be real, substantial, and irreparable. Irreparable harm exists when a party has no adequate legal remedy, usually because its injuries could not be fully compensated through an award of monetary damages. That's basically the only time that they exist. If money solves your problem, then money solves your problem. So, yeah, if it can be solved with money, it's not irreparable. Minnesota courts have held that loss of business and consumer goodwill can constitute irreparable harm. Okay. Maybe. Furthermore, another Minnesota district court has held that social media posts containing statements which cause business losses can constitute irreparable harm, and that granting injunctive relief barring such posts. And here apparently is a case where a court granted injunctive relief that prohibited an individual from making posts on Facebook or GoFundMe. Well, that other courts are doing it, right? My concerns, as always, of course, are the First Amendment. What are the First Amendment concerns? Because the thing you want them to do or not do, in this case, is speech. So there's that. In this case, the defendants have uttered numerous false and defamatory statements that have damaged the business. The problem is, of course, we don't know that they're false and defamatory. At least legally, we don't know that yet. Right? We don't know that. That's the point of the lawsuit. Right? So we don't know that yet. Defendants have made it clear that she intends to use her social media posts to put plaintiff 7M out of business. Well, if she wants to put them out of business through legal means, that's proper. Just because you have hostile intention against someone doesn't make it illegal either, right? It's like, I don't like Nike. I'm going to say Nike sucks until people stop buying Nike products. You know, if that's your opinion, that's your opinion. It's fine. Okay. Yeah. All right. Okay. Hold on, there's a problem with the bot. So let me go and try to fix that real fast. All right, hopefully that'll solve whatever problem we're having. Let's get back to the article. Okay, let's see where we were. The defendants have made it clear that she intends to use her social media posts. In my opinion, does it have merit? Yes, it has merit. I've said it has merit many times. Otherwise, we wouldn't have made it past the motion to dismiss. Or do you think, are you asking me, does this have merit? What are you asking me has merit? I don't know if this has merit yet. I haven't finished reading it yet. I'll get back to you. The defendants have made it clear that she intends to use social media posts to put 7M out of business. Defendant have even blatantly boasted about interfering with planned 7M contract with the Los Angeles Clippers. Even when confronting with posting materials that are false, defendants have refused to take such posts down, and instead characterized her false statements as opinion when confronted. Yeah, that's probably not going to work. Overall, defendants' persistent false and defamatory social media posts have cost plaintiff 7M numerous contracts and significantly damaged its reputation among the professional community. Defendant's social media posts have not only prejudiced the plaintiff in business, but also in this litigation. I'm not even sure that's possible. How could her social media posts prejudice you within the context of the litigation itself? I'm not even sure that's possible. That's what the litigation is meant to solve. Okay. Defendants have made multiple false statements regarding this lawsuit, such that plaintiffs are completely barred from obtaining discovery from defendant without a crystal ball when this is not the case. If defendants continues to make false statements pertaining to this lawsuit, she will restrict the plaintiff's access to a fair trial. That seems very doubtful. If social media posts, especially those which contain misstatements about the court's ruling intended to inappropriately influence litigation, restrict plaintiff's access to a fair trial, equitable relief is appropriate. I seriously doubt that very much. I don't think you're going to have any problem finding a fair jury. I mean, Katie Joy Paulson may have 200,000 plus subscribers, but I don't think you're going to have any problem finding people who have never ever heard of her or any of this stuff. Because, I mean, 200,000 people is a lot, but it's 200,000 people, in the world. In her community, finding people that thought about her, it's not going to be hard. So that's prejudiced her in a way that's going to prevent a fair trial. I don't think so. Philip Estral says, "You're the best law tuber." Well, thank you very much. I appreciate that. That's very, very kind. I do my best to be fair and reasonable and try to adjudicate things using appropriate legal standards. I appreciate it. I really do. Overall, defendants Katie Joy's constant posting of defamatory material has damaged Plaintiff 7M, both in business and litigation. Is it possible to quantify the damage that will continue to occur to Plaintiff 7M finances and reputation, goodwill, and talent community, and what it would cost to repair the damages caused to the defendant if the temporary injunction is not granted? I'm not sure that's true. I mean, how much more damage would it cause versus the damage she's already caused? Because an injunction, of course, by its very nature, is forward-looking, right? An injunction can only look to the future. It's not meant to rectify the past. And of course, she's already made the waterboarding, kidnapping, human trafficking allegations in the past. An injunction can't fix that. It's already happened. So you would only be looking to stop damage to your business reputation that hasn't already occurred. But of course, your whole complaint is that your reputation has been massively harmed already, as you would expect. So to some degree, one wonders how much damage more Katie Joy Paulson could possibly cause versus what she's already caused, right? An injunction can only stop future harm. All we can do with an injunction is stop her from doing more bad stuff. But like, what more bad stuff is there for her to do is the problem. Like, you can't quantify it. Can you quantify how much it is would compare to how much damage you've already suffered? Because there's your problem. It's like it looks like you're trying to use an injunction to solve problems in the past, and you can't do that. That's what the money's for. Once a proponent for a temporary injunction has shown there's irreparable harm, the next issue is to conduct a Daubert analysis. I'm not sold on the irreparable harm. Irreparable harm might have already occurred, but if it already occurred, an injunction can't solve that because it's already happened. And a Daubert analysis applies multiple factors to determine if an injunction relief is important, including the relationship between the parties, the harm suffered to plaintiff if request is denied, compared to harm suffered by defendant if the restraining order is granted. Yeah, there's a good question. What is the relative balance of harms? On the one balance of harms, we're denying her freedom of speech. On the other balance of harm is further damage to your already crippled reputation. So, like, it's not even clear the balance of harms weighs in your favor at this point. The likelihood of success on the merits. Your likelihood of success is good. That's not your problem. Public policy, there's a problem, right? Because the First Amendment is a public policy too. And the administrative burdens of enforcing. The analysis applies to temporary injunctions. Of course it does. Upon analysis of facts of this case, the majority of the factors clearly weigh in favor. Okay, sell me. The first factor involves the nature and background of the relationship between the parties pre-existing the dispute. You have no relationship pre-existing. Before this dispute, parties have no relationship. I agree. Defendants have no professional or personal affiliation with plaintiff until she began her defamation. Therefore, this factor favors plaintiffs as the status quo supports no contact or commentary between the parties. I don't think so. The status quo favors, that doesn't make sense. The second factor involves balancing the harm to the plaintiffs if the temporary injunction is not granted against the harm to the defendant if the court applies the injunction. The Minnesota Court of Appeals has held this is the most important factor in determining whether a temporary injunction should issue. Okay. For this case, the potential harm to plaintiff 7M gravely outweighs the harm. How? As analyzed above, plaintiff 7M would suffer irreparable harm if defendants continue their false and defamatory coverage. I'm not sold. Right? They've already said, Katie Joy Paulson has already said, the kidnapping, waterboarding, trafficking thing in many, many social media posts up to this point. You have already suffered quite a bit of harm at this point, one would imagine. It's not quite clear that there's much more irreparable harm that could occur in the future. Yeah, I'm not sold on that. The severity of defendants' action, such as claims of human trafficking, waterboarding, operating a cult, could cause irreparable harm. Yeah, but that's the problem. She's already done that. That's the problem. She's already done that. She's already done the claims of human trafficking, waterboarding, and operating a cult. Like, what more is there for the future? Could cause irreparable harm to plaintiff 7M business and consumer goodwill, especially where such allegations are distributed on online platforms to hundreds of thousands. That already happened. That's why you're suing in the first place, 7M. Right? That already happened. She already did that. So, what is the injunction trying to do again? What other than put the toothpaste back in the tube are you trying to get done with an injunction? I don't, yeah. Plaintiff 7M is at risk of losing considerable business and consumer goodwill. You already said you lost it. You've already said that in this document. You've already said in this document you've lost business and consumer goodwill. As you would think that they have. You would think the human trafficking, waterboarding, and operating a cult claims would somewhat be harmful to your business relationships. I totally understand. I get it. But that happened already. What more do you want? Or what more can happen? Right? You think at this point it's possible that like some person is doing business with you and it's just that one more post that's got to be like, oh, okay, now it's the thing. I mean, I don't know what you want this injunction to do. I'm not saying, by the way, the court won't grant it. I'm just saying I'm skeptical for the reasons I'm highlighting. How much this particular judge would track my thinking on this, who can say? I tend to think, as a general proposition, when it comes to freedom of speech issues, I tend to think that as a general proposition, judges grant these kinds of injunctions too freely. And so I can't speak to whether or not this judge would issue it or not. I'm skeptical of it for the reasons I said. Like, what harm are you saying will happen in the future that's not already happened? Therefore, those suffer irreparable harm if temporary injunction is not granted. Will you, though? On the other hand, the harm to the defendant will be minimal. No, I mean, she has a First Amendment right. She has the right to freedom of speech. And so her harm is not nothing. To bar a temporary injunction, the opponent is not held to an irreparable harm standard, but still must show substantial harm. Restraining one from coercively targeting one's business or publishing statements on the internet regarding plaintiff do not pose a risk of substantial harm. Yes, they do. They absolutely do. She has a right to make statements about 7M to the extent they're true, and to the extent that there are her opinion, right, versus fact. She has First Amendment rights. Those First Amendment rights do not include defamation, but they do include the right to say truthful things, and they do include the right to true opinions. And so you saying, well, she can't publish her statements is not a harm. The First Amendment would like to have a word with you. For a temporary injunction, plaintiff simply asks the court to enjoin defendant from posting materials about the plaintiff or their associates. In toto, there's no evidence defendants will suffer any harm. Bullshit. You're literally preventing her from speaking. That's a harm that you are not justifying, in my humble opinion. The plaintiff can demonstrate likelihood of success on the merits. I'll give you likelihood of success on the merits at this point. I'll give you that factor. So you got that going for you. The next factor requires the court to look at the likelihood one party or the other will prevail. At this point, the likelihood does favor 7M. But of course, I'm saying that in the absence of any sort of substance from Katie Joy Paulson's side. But then again, of course, 7M has pointed out that they've said a lot of really specific harmful things. So even in the absence of a reply from Katie Joy, I'm thinking the balance of probabilities right now is favoring 7M. It's like Katie Joy might be able to get to where she wants to be, but there's a lot to overcome. A lot of specific statements. And her responses to date have been less than encouraging as it relates to her ultimate prospects of success. A court errs in granting temporary injunction relief if proponent cannot show any likelihood of prevailing. However, if a plaintiff makes even a doubtful showing as the likelihood of prevailing, a district court may consider issuing a temporary injunction. In this case, plaintiffs have more than a doubtful chance of prevailing on the merits. I agree. At this stage of proceedings, I'd give you the balance of probabilities. And it's like, I think at this stage you are more likely to win than not, but there's a lot of game left to be played. So, it's not even right to talk about preponderance of the evidence at this point because we don't really have any evidence from Katie Joy yet, nor would we expect to. We just like doing probabilities at this point, but it's like, well, on balance, I think they're probably going to win, but we'll see. Plaintiffs have brought 9 counts against defendants, including defamation and some other stuff. But as the court themselves have already ruled, defamation is basically the backbone of this whole thing. And I tend to agree. So basically, all roads lead to defamation. If they can show a likelihood of prevailing on even one count, the factor weighs in favor of the temporary injunction. Okay, yeah, I'll give you this. I will give you this 7M. This factor does weigh in your favor, but you have other problems. So a claim for defamation requires you to prove three things. The statement communicated to someone other than the plaintiff. You got that. The statement's false. Well, you got evidence of that. And the statement tends to harm the reputation. That you got. So, I mean, on your defamation cause of action, you're looking pretty good. You got communication to a third party in a non-privileged context in a way that would harm your reputation, hurt your business, hurt your esteem, hurt your standing, damages are presumed, right? And it's not even clear you're a public figure, so your standard is probably negligence. And you made a lot of very specific, very aggressive claims that are a bit absurd on their face. So falsity is looking, like you're heading in that direction. So yeah, the balance of probabilities are heading in that direction. If the plaintiff is a public figure, there also must be a showing. I'm not sure any of these people are public figures. In this matter, defendants have published countless posts regarding plaintiff 7M and its associates on social media, which potentially have hundreds of thousands of followers. Defendants' posts, which include but are not limited to outrageous accusations of human trafficking, waterboarding, and cult-like behavior, are false. And there's some evidence to support the proposition they're false, as has been cited in this very motion. Defendants' posts have also damaged plaintiff 7M reputation and opinion in the talent community. That's the problem. Right? That's the problem. Yes, I kind of agree with you that they've harmed your reputation and opinion. That goes to your likelihood of success, but it's hurting you on the other element in terms of the balance of hardships. Because, yeah, your reputation and opinion has already been harmed by the human trafficking, waterboarding, and cult-like behavior. So what more is there for an injunction to do is not clear. Defendants have personally boasted about disparaging 7M's reputation. Disparagement is not the same thing as defamation. And disclosed that she played an active role in destroying any potential business relationships with the Los Angeles Clippers. Again, there is some evidence to support this proposition if you read the relevant evidence in a light favorable to 7M, which is an appropriate way to read it at this point. Furthermore, defendants have failed to substantiate their claims against 7M, at least at this point, but then again, you wouldn't have expected them to, nor could you really consider it at this point, right? They failed to substantiate it, but they're not supposed to yet, right? That's what's supposed to happen next. They failed to provide any corroborating evidence to prove her accusations are true. True, but it's not expected yet. So the failure to have it is not really meaningful. It's like you failed to do something that you're not yet required to do. So when confronted with falsity, defendant simply backtracked and relabeled her statement's fact as opinion. Not encouraging, but also not particularly dispositive. Defendants have had knowledge of falsity of at least some of her statements. Well, she has knowledge that certain people claim them to be false, including people who might be in a position to know about whether or not they're false, which might not quite be the same thing as her knowing that they're false. Let's say that she would have reason to doubt their truth, which is not quite the same thing as saying that she knows that they're false. But she would have reason to doubt they're true. Yeah. Which is relevant, of course, on a balance of probabilities of winning, because if you're trying to prove negligence, that she has evidence that would cause a person of ordinary normal fitness to question their reliability, negligence. Yeah, okay. And a minimum has displayed reckless disregard for falsity. Yeah, well, I think you don't even necessarily need that. She's displayed negligence. Overall, the plaintiffs have, or at least hypothetically, of course, she's displayed negligence because we don't yet know enough to reach that opinion, but we're on the track. Overall, plaintiffs do have a likelihood of success for their defamation, therefore factor weighs in favor. I mean, I'll give them this factor of it. Sure. I'm not so sold on the other factors, to be sure. Why are people giving codes in my chat? What is going on? It's my Discord code? Okay. The link, yeah, okay. If it's not in this stream, check one of my other videos. It's in the description of like pretty much all my videos. But when you create links in StreamYards, it doesn't populate for some reason, but thank you. Let's read on. In the case, public policy favors enjoining defendants on their attacks. Defendants have used their platform to render both heinous and baseless allegations that serve no interest to the public. Well, if they're false, that's correct, but of course we don't know that yet. Further, would not be an improper restriction on defendant's First Amendment right if she's restrained from publishing false and defamatory statements. That's true, it wouldn't be, but then again, that's the very thing we're trying to prove, right? It would not be a violation of her First Amendment to restrain her from publishing false and defamatory statements, which of course, falseness is required, so you could just say defamatory, right? So yes, but that's the very thing we're trying to prove. So you can't, bootstrap yourself that way. Defendants should not be allowed to use their social media platforms to subject plaintiff to immeasurable harm. But you've already said that's already happened. What more immeasurable harm can Katie Joy Paulson cause you at this point? What more is there for her to do? Right? So, yeah. The administrative burden. The final factor looks at the burden of the courts in supervision and enforcement. Requested relief would not require any performance or detailed surveillance. I tend to agree. That factor is to the court. So, yeah, I mean, I agree as to some of this stuff, but the balance of probability is I am not sold, and the harm, I am not sold. Overall, plaintiff's motion for temporary injunction is not granted. Plaintiff 7M will suffer irreparable harm. But you already said you did that. Furthermore, 4 out of the 5 factors weigh in favor of the relief. I'm not sure I agree. Therefore, totality of the factors weighs in favor of the preliminary injunction. In the alternative, the court does not grant a temporary injunction, we require a disclaimer. Yeah, probably not getting any of those things. At least from me, I don't think you're getting any of those things. I'll give you a hearing, but I'm not very happy with this. Because it's like, yeah, what more is there for this court to do at this point in the proceedings? Like, she's already apparently on social media said that you 7M are waterboarders, kidnappers, and human traffickers. She's already caused harm in your community, in your reputation, loss of business opportunities, tortious interference with contracts, and so forth and so on. So, like, what more is there really for her to do here is not clear. Versus, like, the harm to her in this. So I am somewhat disinclined personally to grant this request, at least as it's currently phrased and contemplated. So that's my humble take, but of course a court might disagree. But that's what I think. And then also there is a somewhat related motion for a protective order, which we'll cover very briefly. The underlying basis is the dissemination of information about defendants, in addition to false and defamatory statements, to disseminate personal contact information about plaintiffs and their associates, as well as disseminate court documents which are subject to protective orders in another lawsuit. Well, that's a matter for that court. I mean, for me, personally. If defendants have proven themselves unable to keep private and confidential information, plaintiffs respectfully request a protective order. All right, so what is it you want me to do here? Exactly. So you give me the relevant rule. That's fine. The court may make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. That's fair. The underlying cause of action is statements to the public regarding plaintiffs. In their own social media posts, defendants have expressed their excitement for obtaining discovery against plaintiffs in this matter. Specifically, after being served, defendant posted, "Let's go, discovery is about to get real," firing emoji. Well, I'm glad that she's excited about the discovery. Hopefully she'll find what she's looking for. Defendants have also established a history of posting findings from discovery on social media. Specifically, defendants have posted excerpts from depositions on Instagram. Some of those posts include sensitive and embarrassing information about the person being deposed. Defendants in this matter have served interrogatories and document requests upon plaintiffs, which include requests for private financial information, sensitive and private business records, and medical records. Due to sensitive nature of discovery being requested, defendants' behavior regarding discovery in the past, plaintiffs requestfully respect their following protective orders. Okay. To be entered in this matter, allowing all discovery to be viewed by defendant in the following manner. Okay. So all discovery would be viewed the following way. So what is the scope of the protective order we want? All responses to interrogatories, document requests, and requests for admission shall be viewed at counsel's office. Counsel for defendant shall be the only one allowed to view discovery and take notes. Cell phone and other recordings shall not be permitted in the room. And all depositions, recording transcripts shall be confidential, and the contents thereof shall not be disclosed. That seems overly broad. So I would be disinclined to give them a protective order this broad, right? But you want to prevent the information from discovery in being used outside the courtroom. That I'm more inclined to give you. So I would give you, for example, medical records, social security numbers, addresses, phone numbers, dates of birth, so that kind of thing. I would give you all day long. Addresses, email addresses, social media handles, of people, that kind of stuff. But the only place you can review them is in our office. Like, we're not even going to give it to counsel for counsel's eyes only. Would piss me off on a personal level. Like, if I'm counsel for Katie Joy, whatever her problems are, like, I'm counsel. I can be trusted, and I'm an officer of the court. And you're saying I have to come to your office to view this stuff? That's bullshit. Like, if you want to make it counsel's eyes only, we can talk about that. But that pissed me off as a lawyer that you were doing that. It's like, what did I do to you? I'm an officer of the court. Give me a break. So that's what's going on. It's on the last motion, not the discovery one. No, that was the right one. At least it looks right to me. All right, so yeah, that looks right. Okay, so that's good. So that's what's going on. So what is it? This Wednesday at 9 a.m. Mountain Time. So that's 11 a.m. Eastern Time, I believe. There's a hearing in the Daybell case. I know you're excited. I'm excited too. So we will, of course, be watching that and responding to it, either live or close there too, because we are just going to be the source for all of Daybell things. So any hearings going forward in Daybell, Vallow, or Murdoch, we are going to make efforts to cover every single one of them. And we'll also go back into the past and cover some stuff too. But yeah, so that's what's going on. In terms of all that. Isn't medical records a HIPAA violation? No, it's not. HIPAA protections only apply to covered entities. HIPAA prevents covered entities from releasing medical information. If Katie Joy Paulson got medical documents as part of discovery, she is not a covered entity. She's not a healthcare provider. She's not a healthcare insurance company. She's not a doctor, right? So HIPAA would not apply to her, because HIPAA only requires covered entities, which are defined by law, which, as I stated, are basically medical providers, medical insurance companies, doctors. Those are covered entities. Random Joe is not a covered entity. Random Joe, if they get access to your medical information through legal means, can disclose that information all they want. HIPAA does not operate as a bar. So yeah. And yeah, I heard about the Netflix thing, and I'm absolutely going to cover if there's a Netflix series. We'll absolutely cover that for sure. So that's what's going on. Does it damage your reputation to say you've been kidnapped? To say you yourself have been kidnapped? I don't know. I hadn't really thought about it. I suppose it's possible. If someone falsely claimed that I've been if someone falsely claimed that I've been kidnapped, would I consider my reputation harmed? Well, I mean, Rob is currently holding me hostage using the unicorn power. So, but I don't know that I feel particularly harmed by that claim. So, there's all that. So, yeah. I'm not sure about all that, if it would harm your claims or not. I'm not sure how that would work or not, if that would harm your reputation. I suppose anything's possible. So, yeah. So let us finish our chat, of course, because we've got Wednesday's live stream of Chad Daybell. But of course, you know how we end these streams. We end these streams using the only way that we know how to end these streams, which is by reading some of Chad Daybell's masterwork. So we are continuing to read from chapter 2 of The Great Gathering, written by Chad Daybell. After the meal, the Norths gave the other couples fond hugs goodbye and wished the Browns well on their new assignment. As they pulled out onto I-15, Tad suggested that they visit his grandfather, Charles North, who lived in Orem. He and Tad had grown particularly close during Tad's time at BYU, and Emma said she had grown fond of him, that she had insisted they name their second son after him. They hadn't seen him in about a month, and when he opened the door, they were stunned by his gaunt face. "Grandpa, I must say you've looked better," Tad said. "Really? I thought that by dropping a few pounds would really help my appearance," he said with a grin. "Actually, I'm glad you stopped by. I've been meaning to talk to you. I've been having some stomach pains, and the doctor gave me some tests last week." Grandpa North motioned them inside the house, and they sat on the couch while he took a seat with his recliner. Once they were settled, Tad asked, "Did they find your stomach problem?" "He's pretty sure it's cancer." "Whoa, I don't know what to say," Tad said. "Are you going to go get chemotherapy?" Grandpa North shook his head. "I don't think I'll be getting any treatment." "Why not?" Emma asked in surprise. "Maybe I'm just being stubborn, but the government has a plan that I don't want any part of," he said. "As an old Navy vet, the government has always paid my medical bills, so in exchange they think I should be part of a new program they're working on. They're willing to give me chemotherapy at no cost, but they also want to implant a microchip in me." "A microchip?" Tad said. "Where would they put it? In your brain?" Grandpa North laughed. "That might actually help my mental capacity, but no. They want to put it in the back of my right hand." "The government has kept this project pretty quiet. They're starting with people like me who are dependent on the government, but the rumor is they'll want to want everyone to get chip implants." "You're kidding. I certainly don't want one," Emma said. "I've heard of chips being put into pets to help identify them if they get lost, but I don't think humans need them." "Well, neither do I, but they're saying it's the wave of the future," Grandpa North said. "I want to be able to pass my hand over a scanner, and the chip would immediately tell the computer all my medical information. The chip can also contain other items, such as a person's financial history. They say you could even pay bills with it." "That sounds too intrusive," Tad said. "But the government won't pay your medical bills unless you help test it?" "That's right. I'm kind of stuck in the middle. I do support my country, and I can see how this chip might make everyday life go smoother, but it just doesn't feel right. It's too much like Big Brother watching my every move." "What is the world coming to?" Emma asked, feeling annoyed. Grandpa North shrugged. "I can see the government's reasons for wanting it. Identity theft and computer fraud are becoming so common. The chip might be the only way to protect our financial assets. The wealthiest citizens are so tired of being victimized that they are really behind the chip, and their lobbyists are pressuring the government to go forward with it. On paper, it sounds like a great idea." Emma shook her head. "You and me both, Emma. You and me both. That doesn't seem going too far. Or apologize. That seems to be going too far. It still doesn't feel right to implant something in your body simply to protect your money. Their arguments are pretty solid, Grandpa North replied. The FBI claims it could make crime nearly non existent. The chip would be linked to the GPS tracking system, so the police could capture any suspect simply by tracing the location of the chip. I could see larger corporations liking it. For example, when someone calls in to use a sick day, his boss could easily check if the employee is out playing a round of golf when he's supposed to be home in bed. Why haven't we heard about this? Tad asked. You would think people would want to know about it. It's already being used by private companies in Europe, Grandpa North said. There's a dance club in France that gives regular guests a big discount if they use the chip to purchase meals. So it's been proven to work. I don't see how they'll force all people to take the chip, though, Emma said. I certainly don't want some chip bulging out of my skin. You would hardly notice it was there, Grandpa North said. They use a little gun-like tool that implants it under your skin, and you're as good as new. Don't you think religious groups across the country will oppose it? Tad asked. Grandpa North smiled sadly. The government has already worked out ways to halt any opposition. Just watch. I bet Americans will soon be having them planted voluntarily. Emma couldn't believe her ears. Voluntarily? I really doubt that would happen. The doctor I've been seeing says the government is preparing to put a positive spin on it, Grandpa North said. They think it will even boost consumer spending. One plan is to give a $2,000 tax credit to anyone who receives a chip in their first 30 days after its introduction. Don't you think most people will jump at the chance to get a lot of money for simply having the chips put in the back of their hands? They will be under the skin and hardly noticeable. Imagine a family of 6. That's $12,000 right there. I see what you mean, Tad said, a bit discouraged. When you tell me I could get $10,000 for us and the kids, it could change my mind. Emma glared at her husband. Don't even think about it. Don't worry, Tad told her. I don't plan on it. Tad then proceeded to give Grandpa North a wonderful priesthood blessing, encouraging him to follow the promptings of the Holy Ghost when it came to dealing with his doctor and the government. After the blessing, Grandpa North had tears in his eyes. Thank you, he said. I'm not going to get the chip, even if it costs me my life. Thus ends Chapter 2. Well, great. Thus, I get in plan voluntarily just to F with him, Q squared. Well, let's give some commentary and critique for Chapter 2 of this wonderful story that we've been reading together. So in Chapter 2 of this wonderful story, we've learned that the NBA has sadly folded, as it is no longer financially viable, and instead been replaced by the cross between rugby and ultimate fighting that is Conquest, a game that involves mazes in a basketball-sized arena and human contact that occasionally even results in deaths, and the people love it. Also, we've learned the government is planning to plant chips in everyone's hand, which I've read Revelation. I know exactly where this is going, right? Right? The mark of the beast, right, on their hand or their forehead. I know what we're doing. I'm picking up what's laying down, right? The mark of the beast on the hand and the forehead. I know exactly where this is going, right? So we're going to plant the human chip thing in order to track people's finances and give people a tax break, and they'll be lining up. And apparently, it's being used successfully at a club in France for discounts. So that's exciting. So I think that we have learned that Chad Daybell truly is one of the greatest authors of our time. I am amazed that this has not yet been adapted into a full HBO series, because truly it is the greatest thing that we've ever seen. And if no one else adapts it into an HBO series, I'm going to have to. I'm going to have to get myself and my fellow law tubes together, and we're going to have to give parts, and we're going to have a dramatic work, and we're going to have to stage the thing. It's the only thing for it, guys. The world needs to know. The world needs to know. Well, my friends, that's all for now. So Wednesday at 9:30, I think it is in the morning. I'll get you the exact time on that later. We got some more of the Chad Daybell hearing. So that will be super fun and exciting. And we'll learn more about what's happening in their criminal trial, which is already a story even more messed up and bizarre than anything Chad Daybell wrote. The reality of Chad Daybell and his life and the relationships and what people are doing is crazier than anything that we've read in any of these stories. So the real life drama challenges us all. But that will have to leave us for the moment. Well, my friends, until later, remember, please do all the YouTube things. Like, comment, subscribe. Have you hit the like button? You could hit it right now. You could hit the little up like button, and it would be great. And if the red subscribe button is red, it is red because it's angry with you. You should click it. Remember to do all those YouTube things. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.